decisions, decisions, decisions. Well, we know that there are competing measures for medical marijuana. We know that we've got the D, E, and F. And to go in reverse, we know that F has been designed to favor those particular collectives that are clients of a particular lawyer in town. But it's very weak the way it was worded. It says that the federal government has superior power to the ordinance being passed, and even the city council can modify it. So what's the point of having a people's proposition that can be modified by the city council? The whole point of a proposition is that the people can create laws themselves. So handing control back to the city council doesn't work. Giving control to the feds, of course, doesn't work. And having a particular group of people try to benefit from and control the medical marijuana phenomenon doesn't work. So I don't like F. Now D and E are essentially the same, except that D survives and E's been abandoned by the city, or rather by the clique, in favor of the one of the city as kind of a combined mindfuck. But it's not really good for the city of LA because the limitation is on just those collectives that existed as of 2007. So obviously it's for those people. These legislations are both created for the benefit of a certain agenda and a certain clique. The distinction there is that many of them, because of zoning and other rules, will actually not be able to exist, and many have shut down. So the actual number of collectives may be like 40, 50 in LA, which will lead to its own terrible problems of zoning and overcrowding and profiteering and too much medicine and too much marijuana medicine and too much money at those locations. So it's going to lead to unintended consequences if we close all of the collectives like that. And yet, in light of the new Riverside decision, I'm worried that if we vote no on all of the above, that will be inadvertently sending a message that the city council members that are against storefront dispensaries can use. And that message will be, see, the people of the city of LA didn't even vote to have a dispensary ordinance. And then if they ban them under the case of Riverside, we will have a very hard uphill battle to try to save the day, because the Riverside case says the cities can ban, at least in dicta, and I'll go into that another time. But long story short, let's just say that 99% of the things that are in that Riverside case are dicta. In other words, the court went on to beyond what it should have done. It started legislating from the bench, giving out opinions or dicta that go beyond the fact pattern set forth in the case. The fact pattern set forth in that case is actually very narrow. So I encourage those of you that are scholarly to read footnote 4 very carefully. Footnote 4 in that case. And it tells you that the whole case is predicated on a set of facts that's basically irrelevant to 99% of the storefront collectives in this city. However, the dicta in there is the perception. The perception is the reality. The Supreme Court says that you can ban dispensaries in a city, and the cities believe it, and that appears to be where the law is. So I think it will be dangerous to vote no on all three of these, and therefore I'm tending to think now that I may vote yes on all three, even though I hate them, in the hope that if all three pass, it will again go back to city council, and then there will be some possibility of some political and court pressure to make sure that a fair ordinance comes through. And I'm concerned that if we vote no on all of them to try to send a message that none of these is adequate, that it may be misinterpreted by political people with an agenda to say that people in LA don't even want storefront dispensaries. This is a difficult puzzle. I look forward to your comments and ideas back. Take good care. If you want to get my consultation, I'm always here with my consultation. Remember, even if storefront dispensaries close, the Riverside case does not even mention the word delivery. And Health and Safety Code 11352.768 clearly states that there is such a thing as mobile retail outlets or delivery. So there still will be collectives, there still will be collective cultivation, there still is the collective defense. We need to save the storefront dispensaries in LA. Talk to you soon. By the way, I'll take the Pepsi challenge with any other attorney on my comprehensive 1 hour consultation on medical marijuana law. I'd be very happy to give you my book and walk you through it. Just to give me a call and we'll book your appointment. It is $500, and I also have an upsell, which is my $1,000 do-it-yourself corporate kit. Thanks very much for touching base.